Story 1. I am not a lawyer, but I was robbed at gunpoint in my home. The kicker was that the shoes he wore to court were the same ones he had stolen from my house. The judge asked if I wanted them back. I said yes, so the defendant removed them and walked back in his socks. I donated the shoes as it was more about the principle. Story 2. I had a client charged with battery. The victim did not support the prosecution's case and was reluctant to testify. There was another witness who said my client hit the victim, so it did not look good. The prosecutor and I were talking by the courtroom doors before court started when the witness walked in. She looked directly at my client, who was sitting less than 5 feet away, then scanned the room and asked where the defendant was. The prosecutor and I exchanged a glance, and he said he needed to check on something. A few minutes later, he told me he was dismissing the case. Story 3. I was testifying for the defense. A young man had been arrested for assaulting a police officer, allegedly throwing bottles during unrest in Oakland following the verdict in the trial for the police officer who shot Oscar Grant in the back on the Bay Area Rapid Transit platform. I had been filming and caught his arrest on video. His brother found my footage on YouTube and asked me to testify. I had only seen bottles being thrown from a corner of a parking lot behind me, with the bottles flying over my shoulder. The defendant was in a group in front of me. On the stand, the prosecutor seemed to think I knew the defendant and was there basically committing perjury on his behalf. I explained why I had been there that night, that I had never seen the man before, had not been coached by the defense, and had not been paid other than a small amount for travel and time. Finally, exasperated after much back and forth, the prosecutor said, "Well, if you do not know the defendant, then why are you here testifying for him?" I thought for a moment and said, "I guess I just would not want an innocent man to be convicted for a crime he did not commit." He became visibly flustered and quickly moved on, trying to insinuate that if I did not know him, how would I have known to be looking in his direction to see whether he was throwing things? I tried to explain that if you are looking at a group of random people and one of them throws something, you naturally fixate on that person. But because nobody in that group threw anything, there was nothing to notice in the first place. It looked like the police just grabbed him at random. They rested. The defense attorney bought me lunch down the street, and then he received a call from his colleague that the jury took only 10 minutes to return a not guilty verdict on the assault charge. They said my response was legendary, and that no attorney should ever ask a question they do not already know the answer to. The prosecutor seemed to have a narrative about a prior relationship to the defendant that he assumed was accurate and was trying to call my credibility into question. Story 4. When the petitioner's attorney called me my brother's name while I was on the stand, I corrected him. My brother is a shitbag and I don't associate with him anymore. He has a lengthy criminal history, which occasionally appears during traffic stops. I was in court over custody of my oldest, and her mother's attorney was trying to paint me as a hypocrite for being an addict. I denied it all on the stand, and he said, "Now, James, I must remind you that you are under oath, and by denying this you are committing perjury." I stared him dead in the face and said, "My name is Bill. James is my brother." Even the judge laughed. The only reason we did not bring it up sooner was that we knew he had submitted it as evidence but did not know why. I wanted to see what he was trying to do. Story 5. We had major problems with a landlord. He tried to enter without warning, did not respond to repair requests, and was aggressive when speaking with us. When he decided to sell the place, he did not check with us about visits and showed up unannounced with potential buyers. We asked him to leave. He eventually did, but that evening he called to threaten us. We sent emails reminding him of our rights as tenants, and he replied by threatening us in an email. We ended up in a local small claims court. He fabricated a story that we were terrible tenants and were trying to discourage buyers. We showed the judge the emails and the police complaint we had filed a few days earlier. The judge could not believe the landlord's behavior, issued a formal warning, and awarded us 3 months of free rent. In the end, he used a real estate company to sell the place. The sale went smoothly, and we still live there with lovely landlords who are not completely unreasonable. Story 6. My client was riding his motorcycle on a relatively calm street when a man exited his garage without looking and ran over him. At the deposition, The man brought a witness who had been in the passenger seat. The witness maintained that my client was driving too fast and there was no time to brake. I asked the witness the same question, several times in different ways, making him tell the story again. On the fourth telling, already a bit frustrated, he let it slip. Look, I have already told you. We were exiting the garage, and as soon as I bent down to get my cell phone from the car's floor. Wait, so you did not even see the crash? There was no coming back from that. Story 7. In a parental termination case I was prosecuting, the father said he had changed his life and worked the Alcoholics Anonymous program. When I asked what step he was on, he proudly said step 3. He could not explain what step 3 was or identify step 2. Parental rights were terminated. Story 8. It was my 3rd month of practice. I was in family law at the time, representing the mother in a petition for a restraining order against her boyfriend, the child's father. At issue in the broader case were child visitation, custody, and support, but the day's hearing was just on the restraining order. We had pretty good facts, but the case was primarily based on the testimony of the parties. My client was far more credible as a witness, so I felt confident. 10 minutes before the hearing, my client showed up. I gave her a last-minute preparation on what to expect, and then she said, "I'm glad I'm going through with this. I can't deal with it anymore, and he's just getting worse." To top it off, he left me a drunken, ranting voicemail on Saturday. "You have your phone with you?" "Yes." We played the voicemail. It was a full 2 minutes of the ex-boyfriend screaming things like, "I should have fucking killed you when we were together. You were always such a bitch. And, I hope you burned to death in a fire." I did not have time to ask her why she had not told me about the voicemail before the bailiff called our case. We sat down, the judge asked if either side had additional evidence, and I asked for permission to play the voicemail. The ex-boyfriend, who did not have an attorney, did not object, so I played the whole nasty 2-minute rant in open court. The judge said, "We are going to take a brief recess before I issue my ruling. If the parties want to meet and confer in the hall, they are welcome to." The boyfriend realized he was in trouble. We settled the entire case then and there. My client got her wish list in terms of custody, supervised visitation, child support, and the restraining order as well. Story 9. I practiced insurance defense and was handed a file to take over involving a slip and fall. A man tripped on a hose and tore his anterior cruciate ligament. The partner had taken the man's deposition already, so I read the transcript. I am a Michigan football fan and had watched every game for 20 years. The man testified that he was the starting safety for a rival team for several years and that he had graduated with a double major that did not exist at that school. I immediately knew this was false. My partner did not see the discrepancies, so I dug deeper. He lied about many things unrelated to the fall. I eventually found high school records documenting head trauma, knee injuries, and a slip and fall injury a few months after the incident in our case. He also testified that he had rehabilitated from anterior cruciate ligament surgery after 1 month. We filed a motion for fraud on the court, and the case settled immediately. Story 10. I am not a lawyer, but I am currently in a custody battle. The mother is saying I cannot be trusted because I have been refusing to take our child to the therapist. The therapist testified that I could not bring our child in because therapy requires the consent of both parents, and the mother has withdrawn her consent. Story 11. A very abbreviated account. I was prosecuting a convenience store owner for luring a young girl who regularly came into the store to a section at the back, then groping, fondling, and kissing her, a charge of child enticement. It was the only area of the store without surveillance camera coverage. According to the video timestamps, they were in the back room for 2 minutes and 17 seconds. Among the defense arguments was that there was not enough time for anything to happen. In my rebuttal during closing arguments, I asked the jury to imagine what could occur in that time. I then asked them to close their eyes while I timed 2 minutes and 17 seconds on my watch in silence. After about 60 seconds, 2 jurors began to cry. I knew the defendant would be found guilty right then. Story 12. I sued a former employer for $3,500 in unpaid wages. It was a slam dunk. I had a letter stating my salary and pay stubs showing lower payments, so in my opinion I did not hire a lawyer to save on fees. The company attempted the same tactic. I showed up to court and the local office. Manager presented an affidavit from the CEO claiming he was authorized to represent the company. The judge asked, "Are you an attorney?" He replied, "No, just an employee. A company cannot appear in court without a licensed attorney." The judge immediately ruled in my favor. I felt fantastic. Story 13. I worked on a case involving defective processors. In discovery, we obtained emails from the defendant's engineers who worked on the processors. They were in an Asian country, but the emails were in English because they were addressed to United States executives. One of the more senior engineers laid out the exact defect we were suing over, explained what the problem was and why it was their fault, and finished with, "This is a big problem. We ship crap to customers." Needless to say, we emphasized that at mediation and they settled shortly after. Story 14. My mother hit a man on a bicycle with her car in a parking lot. She claimed he had hit her and wanted to countersue the cyclist for frightening her. In her deposition, she began every sentence by saying she had hit him. Story 15. I represented an elderly Indian couple who did not speak English well and owned a rental property. They had a tenant who had not paid rent in over 6 months. They tried to evict her on their own, but at court the tenant produced handwritten notes they had given her the year before thanking her for payment. The notes were undated, and the tenant added recent dates herself. The tenant also produced a partial certified check receipt, but most of it was illegible. Because of their limited English, they had difficulty understanding the questions and giving coherent answers, so they lost the initial case. They hired me to counter the tenant's false claims. We refiled the eviction. I had my clients obtain their banking records to show the date the certified check was deposited into their account. The plan was to let the tenant make the same arguments and then present the banking statements showing the deposit date. My clients also found a photocopy of one of their notes, but it was undated, unlike the copy the tenant had presented previously. When the judge realized the documents dated from the previous year, his face turned bright red and he asked the tenant, "What year did you make this payment?" The tenant began to say she could not be sure, and the judge cut her off loudly. "What year?" The court granted the eviction. When the tenant arrived at court, I watched her get out of her car, walk to the trunk, pull out a wheelchair, and remain in it for the duration of the hearing. After the judge left the courtroom, she folded the wheelchair, carried it to her car, and muttered that she hated lawyers. It was a very satisfying day. Story 16. This is not mine but my mother's story. She was fighting for custody on behalf of the father, trying to prove that the children were living in subpar conditions with their drug-addicted mother despite the ample child support provided. It was a tough case because courts are so hesitant to remove children from their mothers. Then the mother blurted out that she had been feeding the children cat food to prove that she would not let them starve. Needless to say, the judge did not accept that as a reason for the children to remain with their mother. Story 17. When I compared the scanned copy of the deed provided by opposing counsel with the original my client later provided, I found that the scanned copy contained a witness signature that did not appear on the original. Story 18. At a restraining order trial, it was my client's word against his regarding a sexual assault. He dressed well and behaved appropriately during most of his testimony. Then he was asked a series of open-ended questions and said something like, "She kept coming up on me with that fucking pussy," allegedly during a lecture. As soon as he said it, a look crossed both his and the judge's faces, and everyone knew the ruse of a respectable young gentleman had failed. I won. Story 19. My client was accused of brutally murdering a dog. A police officer testified that there was no blood testing, no body was ever found, and that the dog could have run away. An eyewitness said she saw the killing down the hallway from the dining room. The police officer testified there was no hallway, and that the dining room was on a different level of the house than where the alleged killing occurred. Then the person who had been leading a lynch mob against my client around town for the previous year testified that she had been in the apartment between the two visits by the police officer to evaluate the scene. There was no body, the crime scene had been compromised, the witness could not see anything, and the police admitted there was no proof the dog was dead. The closing argument lasted 3 seconds. "Your Honor, I am asking for an acquittal. Edit. My first award, thanks. For those who asked, this was in Canada and received considerable media attention prior to trial. Story 20. I am not a lawyer, but we had no evidence that the woman who slammed into my stopped car going 85 miles per hour was drunk until she admitted it on tape during her deposition. She barged into the deposition and demanded to go first, calling me a lying bitch. She told my lawyer that the police report was wrong. It said she was coming from the movie theater, but she was actually coming from her friend's bar. Did you have anything to drink at your friend's bar? Of course. How many drinks? I don't know. They just kept my glass full. Did you take any medicine that day? Methadone and medication for low blood pressure. I see. The police had refused to administer a breathalyzer test at the scene because her husband was a firefighter they knew personally. They told her to go home, sober up, and go to the hospital later. I heard the whole thing but had no proof until she handed it to me. They settled the same day. Story 21. I am not a lawyer. Years ago, I had to do something at a strip mall in a bad part of town. It took about 20 minutes, and when I returned, my car had been towed. I took an Uber to the tow yard. A large sign said cash only. I had to call another Uber, go to the automated teller machine, return, and pay them about $300. I received a shoddy handwritten receipt that was itemized. I went home and searched online. I found they violated the law in 3 ways. They towed my car illegally. They illegally refused to accept credit cards, and they added multiple charges the law calls unreasonable, such as dolly fees and load and unload fees. I took them to small claims court. The judge began by asking the tow yard owner about his relationship with the property owner and how the decision was made to tow my car. Oh, the owner answered, my cousin works there. If he says tow, I tow. It is 100% legal. The judge's eyebrows rose. But, the owner continued, what I detest most, Your Honor, is this person claiming I do not take credit cards. I am a businessman. I take credit cards all the time. He is a lowlife who does not have any credit or debit cards. That is why he wanted to pay cash. I was inwardly thinking, hold it. And the judge saw me smiling, shifting in my seat, and patting my manila folder of receipts. Do you actually not have any credit or debit cards? The judge asked me. I pulled out my wallet and showed him my cards. Then I showed a time-stamped photo of the cash-only sign I had taken that day and another photo I had taken the morning of the hearing. The owner mumbled, okay, you got me there, and then offered only, I did not know that. When the judge questioned him about the legality of each unreasonable itemized charge, each violation entitled me to double the total tow charge. Since there were 3 violations, I recovered $1,800 on a $300 payment. Story 22. I trapped a defendant badly once. He testified in a deposition that he had a green arrow to make his left turn and that my client ran the red light. Unfortunately for him, the additional turn lane arrow had been installed 2 months after the crash. The case settled for the insurance policy limits 1 week later. Story 23. I was reviewing the transcript of an interview with a child. The child made incriminating statements against my client. At one point, when discussing the allegations, the child used an odd word, but I did not think much of it. A few days later, I watched a video of the child interacting with their grandmother, who dislikes my client, from about a week before that interview. The grandmother used the exact same odd word in the same context the child later used it. At that moment, it became clear the child had been coached. It was the first real aha moment of my career. Story 24. When I found a video on Facebook of the plaintiff squatting 300 pounds the month before his deposition, it was striking. He had claimed he could not work and had back injuries after a minor car accident. As a follow-up, I sent the video to his attorney after the deposition and the case was dropped. He had denied being able to work out or lift anything during his deposition. That was untrue. I agree this is unfair to people with legitimate injuries, who others quickly label litigious. Story 25. I can't believe I'm about to say this. Not a lawyer, but here goes laughing out loud. I tried to sell my home myself, and the buyers wanted a term period for a land contract before getting their own mortgage. I agreed to 1 year, had a simple contract drawn up, and after we both signed it, everything seemed fine. Within 30 days, they presented me with their own legally drawn land contract that was pages long to protect their investment. Around page 3, it clearly stated that if the home burned down, the purchaser would receive all insurance proceeds. First, I still had a mortgage and the proceeds would legally go to pay that off. Second, that was a very targeted clause. It did not refer to general destruction of the house, and the property is surrounded by woods and waterways. Page 4 stated that this would remain a land contract until my mortgage was paid in full, so they would never buy it outright. I returned it to them with a letter stating those two things would not happen and that I would not sign. They stopped paying, so I began eviction. 6 months later, the lawyer I hired turned out to be incompetent, and I found myself sitting down with their lawyer. He brought out the contract they tried to give me and began talking about their ironclad case based on the agreement. I asked him to show me my signature. The look on his face when he realized it was not there was priceless. After we talked, it turned out he knew them and had written the contract without the burn the house down stipulation. It seems they added that, and he had believed it was a long-term land contract. Not only did I win, I'm pretty sure they lost a lawyer friend. Story 26. I bought a hurricane door from a contractor listed on our state hurricane readiness website. He took $5,000, and after about 3 weeks of carpentry or scheduling issues, he stopped communicating. I sued both him and his company, which was important. On the day of the hearing, I was young and an optimist, so I figured I did not need a lawyer. A local news station covered my story and interviewed me. I wore my only $99 suit and went downtown. The contractor did not appear and instead sent the company office manager. The arbitrator listened to her, then asked me to present my side. I explained the situation and showed documentation of what I had done and when. The arbitrator looked at the office manager and said I had enough evidence to prove her wrong, and even if I did not, because her boss Michael had been specifically named in the suit and failed to appear, he was ruling in favor of the plaintiff. A judgment does not guarantee payment, so I still may not get the money, but you still owe me $5,000, Michael. I thought, fuck my life, when I first worried about the counterclaim, but I left relieved that the ruling was in my favor. Story 27. My client has been keeping her son away from his father because the father has a new child. She is concerned that her son will act violently toward the new child and that she could be held liable. Judge, that is not even a defense. Story 28. It was not exactly a knew you would win moment, but I received a hidden shout out from a federal judge in a ruling I consider one of the high points of my career. Before my hearing for an emergency injunction against the United States Department of Agriculture, I watched the hearing before mine, a trademark infringement case. At the end of that hearing, the judge accidentally used a pun and could not stop laughing. She was literally in tears. I decided to use a pun in my hearing and accused the United States Department of Agriculture of engaging in a shell game by diverting federal funds to an egg industry trade group. The judge called me on it but laughed heartily. My client won. The judge threatened to put the Secretary of Agriculture in jail. A major newspaper reported that the judge winced at my puns but agreed with my arguments. The written ruling ended with an injunction barring the United States Department of Agriculture from using the funds for any plans they may be hatching. Undeniable shout out. Story 29. I am not a lawyer, but I worked as a paralegal for a law firm. We were defending a claim worth tens of thousands of pounds against our client, a holiday home. A woman had tripped over a speed bump while walking back to her caravan and injured her knee. The fall was genuine. The question was whose fault it was. She said it was the holiday home's fault because she had not seen the speed bump due to low lighting and poor markings. The claim had dragged on for months and reached court. During questioning, when our barrister asked how she knew the speed bump was poorly marked, she replied that she remembered thinking it was not well marked as she walked up to it. Needless to say, it was a short day in court after that. Story 30. Not a lawyer, but I played one in small claims court. My lease had an exit clause that said if I fronted 2 months' rent, they would work to release my unit and return any unused rent. I checked with the office ahead of time. They assured me there was a waiting list, so I gave them the 2 months and moved. They never returned a dime. I talked to the new tenant and confirmed they moved in a week later. In court, the judge commented that he did not see anything explicitly saying they would return and used rent, even though that intent had been stated to me several times. A representative from the leasing office piped up, "Your Honor, in almost every case we can return some money, but in this case we did not have a tenant in the 2 months after he left." The judge gave the case back to me, and I presented an affidavit from the new tenant confirming the move-in date. The judge awarded me double what they owed. It turned out the leasing office staff thought they could lie to me and keep my excess rent. Story 31. I clerk for a judge. We had a low-level thief in our courtroom who had robbed one of his neighbor's houses during the winter in Colorado. The police followed his footprints back to his house, where he was found with the stolen items, a small quantity of drugs, and a cheap handgun. He was an idiot. Story 32. Not a lawyer, but my girlfriend had a very minor nose-to-tail collision, and a rookie police officer who happened to drive by booked her on massive charges and fines. She went to trial, and her lawyer tore the officer's report apart. In the report, the officer listed her ethnicity as African even though she is white and European, put the wrong date and street name, and did not get the other witnesses' details. The prosecution and the officer argued that because she had signed the witness statement, any mistakes were accidental and the statement reflected what happened. Her lawyer asked the officer to show the court her signature on the statement. He looked at it and said he must have forgotten to include it. The prosecutor and several police officers in court audibly groaned. The judge adjourned for 10 minutes. After recess, the judge threw the case out and reprimanded the prosecutor for taking such a ridiculous case to trial. Story 33. I am not a lawyer. I was a volunteer family advocate who worked with families falsely accused of child abuse. Part of that work was going to court with them. I was contacted by a family whose children had been placed in foster care because of alleged parental drug use. The parents insisted they did not use drugs and felt no one would believe them. They had a court-appointed attorney who did little beyond telling them to stop using drugs. I was skeptical. I told them to request their case file for me to review. They obtained the file and I reviewed it. I saw claims and court findings of drug use but no test results in the paperwork. I told them to request the results. The caseworker refused to provide the actual results, and the laboratory refused as well. I arranged for independent testing at a different laboratory. The results were negative. There were 4 months until the next court date. Every time Child Protective Services tested them, the parents immediately obtained a second test at another laboratory. All those tests were negative. I told the parents to instruct their attorney to request any positive test results in court. He would not. I grew frustrated. On the day of court, I carried a stack of negative drug test results in my bag. The attorney would not look at them and was openly hostile to my involvement. Court started. I had been in this judge's courtroom before with other families. The Child Protective Services supervisor stood and said the parents had 12 positive drug screens in the past 6 months. The attorney asked her for the results. She said she did not have them. I handed the negative results to the mother sitting next to the attorney. When the judge observed that the mother looked like she might have a stroke and asked what was happening, I stood and explained that we had negative tests taken immediately after the mandated tests that Child Protective Services claimed were positive. I explained that the parents had attempted to obtain copies of their results and had been refused, and that they consistently denied drug use with negative tests to support their claim. The judge ordered Child Protective Services to provide copies of all drug test results at a hearing in 1 week. At that hearing, the case was closed and the children were released from foster care. The family never received an apology. They were too traumatized to pursue one and moved away within a month. Story 34. Not a lawyer, just a very observant girlfriend. My boyfriend's car was involved in an accident. He was parked in an area where, during certain hours, parking was not permitted because it would block semi-trucks from maneuvering to deliver goods at a steel plant. A woman backed her vehicle into the driver's side door of his Ford Fusion. Police were called for insurance purposes. My boyfriend said the police officer and the woman appeared to know each other and were on a first-name basis. He received a parking ticket. It took a long time for the insurance companies to sort it out because the woman did not think she was at fault since he was parked illegally. That does not excuse hitting someone's car and getting off scot-free. She ended up paying his deductible. This is where the harassment from the local police department began. He received a letter from the magistrate stating he had failed to pay a parking ticket and that a bench warrant would be issued if he did not pay it, or he could request a hearing. He planned to pay it, reviewed the paperwork, and found that the vehicle they said was parked illegally had been traded in before the ticket was issued. The ticket indicated a white Toyota Tundra, but the license plate section was not filled out. It was signed, but the badge number was unreadable. We had traded the Toyota Tundra for a Ford Fusion in December. The ticket was written in February of the following year. I was very angry. I gathered all the evidence for him, including the trade-in paperwork, and he went before the magistrate. The police officer testified that he saw a white Toyota Tundra illegally parked at a location with a parking time restriction and that it was owned by my boyfriend when he ran the tags. I should note that my boyfriend had received several parking tickets while he owned the Toyota Tundra. That is our guess as to how the officer got just enough information to write the ticket. My boyfriend presented his evidence and the judge dismissed the case. The judge said he wanted to speak to the officer afterward and chastised him for wasting the court's time. The officer later told my boyfriend that if he had been contacted, they could have handled it without involving the magistrate. Needless to say, we have not had an issue since. Story 35. I am not a lawyer, but a friend of mine was a defense attorney for driving while intoxicated cases in New York for a while. He defended a man who had been asleep in the back seat of his car while intoxicated when a New York State trooper arrested him. On the stand, the trooper testified that he visually saw the key in the ignition. My friend gave him 3 chances to walk it back. Are you sure, trooper, that you actually saw the key in the ignition? Yes, counselor. When a police officer calls a lawyer counselor, he often does so sarcastically. Then my friend dropped the hammer. You are aware that my client drives a Toyota Prius? Boom. In court, words have defined meanings. Ignition is specifically defined in New York state law as what we commonly understand as the ignition. Some Prius models have a spot for the fob in the dashboard, but that does not change the legal meaning here. The trooper, whose main duty is traffic enforcement, is expected to be knowledgeable about cars. He did not simply make a mistake. He lied on the stand and was caught. Yes, in New York, having the keys on your person while in the car can be considered being in control of the vehicle and can justify an arrest for driving under the influence or driving while intoxicated, but the trooper's perjured testimony could not be separated from the rest of the case. My friend moved for immediate dismissal, and the district attorney did not oppose. The case was dismissed. Nothing happened to the trooper. As to why the trooper did this, promotions and overtime. Imagine running the New York State Police with about 5,000 troopers. What metric do you use to gauge how effectively they are performing? For the most part, troopers ride alone. Trooper number 1 drives around all day on his shift and issues 0 tickets and makes 0 arrests. Trooper number 2 issues, say, 5 tickets a day and makes a driving while intoxicated arrest 4 times a month. You are likely to assume that trooper number 2 is doing his job. An aggressive officer is one who has a lot of tickets and arrests. Court appearances are almost always on overtime. Police unions are specific about overtime pay rates and when they apply. If you are an effective trooper and you write lots of tickets, you will be in court a lot at 1.5 times or sometimes double your hourly rate. Story 36. This did not happen during a trial. It happened to me personally. I was in a car accident when another driver crashed into my car. He was rude, talking tough and blaming me, claiming he knew a bunch of lawyers, and then he threatened to take me to court. I am laid back and remained cordial. We went to the police station and gave statements to the traffic investigator. I did not have a dashboard camera at the time, but the next day I obtained a copy of the closed-circuit television footage that showed the accident. I showed the investigator the video, and he was stunned at how wrong the other driver was. I then told him I was an attorney and that I would decide whether to take the matter to court. The following day, the driver who hit me called. He had also seen the footage and called to settle. I was surprised that the man who had been so aggressive earlier had done a complete turnaround and was suddenly polite and respectful. Amazing what an impact video can have. Story 37. I watched my lawyer have this moment the last time we were in court. Short version, my ex abused my child. I withheld visitation and hired a lawyer. I offered supervised visitation with a plan to return to regular visitation once he completed anger management and parenting classes and had 6 months clean of all substances. On the stand, he said he had been taking prescription medications for 10 years. When the lawyer asked which medications, he listed methadone, Klonopin, Vicodin, OxyContin, and others. He said he began taking them because he injured his back riding his quad. The lawyer repeated the answer and then pointed out the inconsistency. 10 years of heavy medication does not match an injury that happened recently. In summary, the judge granted my request for supervised visits pending his completion of all required steps. He never completed any steps, and our child has not seen him in 4 years. Story 38. I had a lot of these cases when I practiced family law. In one, my client's husband alleged she had been high and nude in public. During cross-examination, he admitted she had been changing out of her bathing suit at the beach and was covered by a towel at all times. He said, "Well, she was naked under the towel." I responded, "Just like you're naked under your clothes right now?" The judge chuckled. Story 39. I am not a lawyer. I was contesting a speeding ticket. In front of the judge it went like this. "Judge, Mr. Crook Eye, you were given a ticket for driving 40 miles per hour in a 30 miles per hour area that is also a school zone on Turnpike Road. How do you plead?" Me, "Your Honor, there is no school zone on Turnpike Road." The judge looks at the paper again, then asks the bailiff, "There is no school zone there, is there?" Bailiff, "No, Your Honor, not to my recollection." Judge, Well, I guess you are free to go, Mr. Crook Eye. Have a nice night." If the officer writes the ticket incorrectly, it must be dismissed entirely. I do not think the officer intended to add extra charges. There was a sign at the top of a hill warning of a bus stop over the crest of the hill. I think he just got confused. Story 40. Not a lawyer, but I defended myself against an utterly baseless charge of using my cell phone while driving. The phone was turned off and charging. When the police officer pulled me over and said he saw me using my cell phone at a traffic light, I told him that was impossible. I said the phone was turned off and I would happily turn it on and show him it had not been used in over 10 minutes. He refused and wrote the ticket for $590. I was angry. I will admit when I am wrong. I once received a ticket for going 81 in a 60 zone that I thought was an 80, and I did not fight that one because I was in the wrong, even if I had not knowingly sped. But this charge was baseless. I did not think I had much chance, but I hoped the officer would not appear. My luck was bad. He did appear, and the prosecutor showed me the officer's statement. He claimed I had told him I had just been checking my messages. When he pulled me over and I told him I would show him my phone, I took screenshots of my call list, my email account, and my text messages. Each screenshot showed the time and the time of the last call, email retrieval, or text sent or received. The judge allowed me to admit the screenshots into evidence because the officer's statement specifically said I had admitted doing something relevant to those screenshots. The screenshots proved I had not used the phone for any of those activities. That disproved the officer's claim. Then, when the officer testified, he said he had seen me pull my phone out of the cup holder, look at it, and put it back. My phone had been on a dash mount when he stopped me. I asked him about the cup holder, and he said it was dash mounted. I had a picture of my car's interior that I had taken earlier because I had thought he might have seen me touching the screen of my car's controls. The picture showed the cup holders are not on the dash. They are in a center console between the driver and passenger seats. That contradicted his testimony. Finally, I produced my cell phone records showing I owned an iPhone 6 Plus at the time of the ticket. I asked him again whether he was certain I had put the phone in a cup holder, and he said he was. I then took a cup from the judge's desk, placed the cup and my phone in front of him, and asked him to try to put the phone in the cup. The iPhone 6 Plus is very large, and I used an OtterBox Defender case. It would not fit in a cup holder. He said his truck had large cup holders and that it would fit in those, but the ticket showed I drive a Toyota Prius, which is not a large car. By then I had shown 3 separate ways that what he claimed could not have happened. The judge interrupted and, noting she would provide advice since I was representing myself, said I had made my point and had done it very well. That was when I knew I had won. The officer was upset, but it was a triumphant moment for me. Story 41. I'm not a lawyer, but I have been up against plenty of them as a union chief steward. Years ago, we had an arbitration related to healthcare costs. The company spent the better part of a year trying to stop us from pursuing the case. The day arrived for our arbitration. The lawyer we were up against was one of 3 and happened to be Paul Newman's nephew. It was my turn to take the stand. His first question, while presenting the grievance as evidence, asked what step was indicated at the top of the page. Our grievance process is a 2-step system, progressing to arbitration if it is not settled. I said it was the 2nd step. He then smugly asked where the 1st step was. I replied that the 1st step is a verbal discussion and that the grievance is put into writing at the 2nd step. He looked surprised but continued. A few questions later, he asked whether base-level insurance for the entire company, instead of a premium option, would satisfy the contract. He was hoping I would argue that base-level coverage was insufficient so he could claim we were seeking premium coverage at base cost. I answered yes. He asked, yes. I repeated that yes, that would satisfy the contract language. He glanced at his notes and then said, no further questions. I knew then that they had no real argument. 6 weeks later, during a contract negotiation meeting, the arbitrator's decision was read. It was immensely satisfying to watch them read the email and see the immediate shift in their demeanor. They went very quiet. We were awarded 100% of the arbitration. Full back pay for all employees who had been overcharged and a reduced rate for the premium insurance. Story 42. I have the opposite story. He knew when he had lost. When I was about 4 years old, I was ill one day, and the only option my parents had to care for me was for my dad to take me to work with him. My dad was an attorney, and he worked at the courthouse where he was arguing a case that day. My dad knew the judge, and I was allowed to lie down on a bench during the arguments between my dad and the opposing counsel. I was a pretty well-behaved kid, I guess, and was quiet. I just lay on the bench and stayed silent. I have vague memories of the incident, but nothing clearly defined. As my dad tells it, the judge grew bored at one point, looked over at me, waved, smiled, and commented on how well-behaved I had been. My dad said that at that moment the opposing counsel knew he had lost the argument and, ultimately, the case. He joked about needing to take me to court more often. Story 43. I was arguing a motion for summary judgment before a judge who had never ruled in my favor. I expected to go home with nothing. He held the hearing in chambers, so we were all sitting around a conference table. I made my arguments and said, I have 6 recent cases supporting this. He replied, and you brought cases? That's amazing. I thought he was being sarcastic, and he was, but not for the reason I assumed. While I thought my motion was dead in the water, he was a step ahead. He did not need to see my precedent. I finished my 10-minute presentation, and then it was opposing counsel's turn. She argued, and when she was done I asked, may I have 1 minute for rebuttal? The judge said, you are not going to need that. And just like that, it clicked. He was ruling in my favor. He had known all along that my motion was solid because he had read it. He had denied my last 2 discovery motions because he already knew where the case was going and there was no point in reviewing more authority. He granted my motion, and that was it. I won the case. No trial was necessary. It is rare to get summary judgment in my area of practice, and I was stunned, excited but stunned. That was my last hearing with him before he retired. It made me rethink how I sized up judges. My expectations had been completely wrong. I should have given him more credit going into the hearing. Story 44. The plaintiff was being deposed in the lawsuit she filed alleging sexual discrimination. She said her boss had made inappropriate innuendos and overtures. The defense attorney asked whether, when the alleged statements or events took place, she was shocked, offended, or damaged. She answered no to each question. The attorney asked why they were there. She replied that, honestly, she would rather not be. Meanwhile, her attorney stared down, scribbling notes and doodling. We ended the deposition and asked her attorney whether this was going away. Later, we received a call offering to settle for $1,000 and a letter of apology. My best guess is that she was pressured by a friend or family member to talk to an attorney, and the lawyers proceeded without really speaking with their client. Story 45. My attorney had this moment during my initial consultation about my boating while intoxicated charge. The sheriff's department conducted the field sobriety tests on the deck of their small vessel in a busy waterway instead of taking me to dry land. The charges were dismissed after my attorney brought this to the attention of the district attorney. I should add that this attorney had been a sheriff's deputy on Marine Patrol for 12 years before going to law school. I interviewed 3 different attorneys. He was the last. The other 2 quoted me $3,000 to $5,000 for the defense. He said he would never tell a client a case was a slam dunk, but he charged $700 and said he would see the case through trial if it was not dismissed, with no additional fee. The case was dismissed by the end of the week. Story 46. It was not at trial, but during a deposition in a case where 2 former employees decided to start their own company in a very niche market. They made their plans on company laptops that they unsuccessfully tried to brick. One of the defendants was being deposed. She said she answered to a higher power than the company. When pressed what that meant, she said herself. That comment was used prominently at trial. Clarification. There is nothing illegal about wanting to leave a company and start your own. The problem was how they did it. They tried to poach existing clients while still employed, breaching their fiduciary duty of loyalty. We also pursued them for intentional interference with contract because they were trying to get existing clients to break their contracts with our client rather than soliciting new clients. Using the company laptop made it much easier to catch them when the company's information technology employee found all the emails. For privacy reasons, I will not say what industry it was. To the person who asked, no, it was not a high-end escort service. I have never had to deal with one of those. I once had to ask a witness about a sugar daddy website, though, so that was interesting. Thanks a bunch for sticking around till the end of the video. Remember to subscribe, and until next time, stay awesome and goodbye.